So for anyone just joining, I want to make sure we're recording properly. I'm just going to state it again. This is Erik Kaardal. He's working on our case on ballot access barriers in Minnesota that we deem unconstitutional. Now, in the last 30 days, Mr. Kaardal, you were recently victorious on behalf of the Minnesota Voters Alliance in U.S. District Court with Judge Wilhelmina Wright that Minneapolis and St. Paul cannot force landlords to give voting instructions to their tenants. You care to tell us a little bit about that case?
Yes, absolutely. That's typical of the type of lawsuits I've done for over 20 years now, and that is that the government attempts to regulate, in this case, property owners, landlords, and do it in an egregious way that violates the Constitution. So in that particular case, both the city of Minneapolis and St. Paul targeted property owners to distribute voting information to tenants. And, it's egregious. The government could have distributed the voter information directly to the tenants, but instead chose to use private parties to distribute the information. And thankfully, under the First Amendment to the US Constitution, that's called government compelled speech, and that's unconstitutional. But you wouldn't know that by the way our city of St. Paul and Minneapolis operate. It's egregious. It tells you how bad our governments are. In this case, local governments, both the city of St. Paul and Minneapolis, which have huge attorney departments, made this egregious error. And I suspect for some sort of dubious political end, but that's not why I was hired. I was hired to invalidate this unconstitutional restriction on property owners.
Following up on that, there are current efforts underway. I live in St. Paul. I am a property owner. I call them landlord penalty proposals. The city council is calling them tenant protection proposals. Some of these have already been established in Minneapolis. So if you could give me your quick take on 3 or 4 of their issues. One is limiting the screening tools that landlords are allowed to use. You can't use credit or criminal backgrounds in your screening. Limits on deposit or rent, what you can charge for your unit. Advance notice sale to tenants living on your property with a penalty of having to pay their relocation costs. And lastly, the just cause for eviction list, saying that you can only kick someone out of your property if you meet one of their requirements in the city ordinance.
Illegal, 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 illegal. All of those aspects are illegal for different reasons. The root cause of all of this, and for those of us who have been around a bit longer, we can remember, as Murray Rothbard would call, a zone of freedom. It used to be that when a landlord rented to a tenant, there was very little government interference. In fact, in the law schools, when I went to law school back in the early 90s, the law school would teach, that the landlord-tenant relationship was a private relationship, a matter for private contract law. But now the governments in Minnesota treat it as a public matter. And so the very origins, you would have to say, it's probably illegal because the cities are usurping powers they don't have to regulate a private relationship like it's a public matter. But then you also have these arguments like in the landlord voting information case that it violates First Amendment compelled speech obligations and other ways. And so we're very interested when that law comes into effect later this summer in doing something about that too. Now, that may be several battles, not just one. I found in the course of practice that one lawsuit you can solve a problem, but you're not going to solve the world's problems. And so this city of St. Paul and Minneapolis have really stuck their foot in it, so to speak. And so now we have to clean it up. It's going to take a long time. When the government enacts dubious regulations like this, it takes a long, long time to undo the damage. And so the damage is here, maybe that people are run out of business, and that's horrific, not only for the property owners, but also for tenants who want responsible private landlords to be serving them. Because if the goal of the city of Minneapolis, St. Paul is to drive private landlords out, all the tenants are going to have as an option are either government-run apartment buildings or
On that same note, does the government have the authority, either federally or statewide, to ban landlords from evictions? This is passed this week due to the virus situation. Do they have that authority?
Oh, it's the same question, really. It goes back to the private property. And so back when I was at the University of Chicago Law School, and libertarian professor Richard Epstein was teaching me, I think his response would be, well, like I said, that landlord-tenant relationship is a private matter, and so the government has no authority to interject itself in that private contract relationship. Now, might be an analogy, though, because with respect to like private property, trespass is absolutely forbidden, but there is the exception of necessity. So it's possible that even under the common law, that there would be a recognition that evictions could be suspended by the government in the case of emergency. But the relationship between the coronavirus and the banning of evictions is tenuous, and it would should also be looked at on a case-by-case basis. I don't think it applies, but that would be the other side's argument would be, well, in a case of emergency, the government can do whatever it wants. But that's not true either. I mean, the government can't confiscate property. The government can't do a lot of things. So why would the government be able to ban evictions during an emergency? That's not clear. But that's sort of something that someone should try to evict a wealthy tenant who refuses to pay their rent because they know they can't be evicted, and see how the courts decide.
Right. That'd be fascinating. One other question before we pivot to our case with you. Yesterday, the legislature in Minnesota approved $330 million of spending. They did not allow input. They did not allow public viewing. They did not allow amendments. Is that constitutional, or have they suspended their rules due to emergency, or suspended them unconstitutionally?
Well, no, that's a very good question. I think the state legislature, as you know, over the sessions, really over the last 30 years, has become less and less responsive to individual legislator amendments and input. And it seems like the legislative leadership just wraps all these bills together sort of in secret, then gets to the votes and gets them through the legislature, and the governor signs. So that's very disappointing. I don't think it's necessarily unconstitutional. A majority of the legislators in each chamber could stop it, but they lacked the courage. And that's one of the things I found, is that the so-called left and right in our state legislative chambers aren't that useful. It's the people outside who are imposing their will on the government that are useful. So, through lawsuits, through basically refusing to be co-opted by the parties, but succeeding legislatively anyway. And so we need groups who participate in the political process, but are also strong enough not to get co-opted by the left-right axes, so that we can win at the Capitol and win in the courts, and basically stop the government illegalities, like we mentioned, the unconstitutional and unnecessary regulation.
Right. Fascinating. Okay, now let's switch to a little discussion on our case that you are representing us on, which started approximately a year ago. And I'm assuming most people watching this, our members, are well aware of the bill we introduced to try and correct the situation that keeps us off the ballot currently in any fair access metric that you look at. The two issues we're dealing with currently are the signer's oath prohibition, which anyone who signs our petitions must solemnly swear that they will not vote at the primary election for the office of which this nominating petition is made. That, under Minnesota statute, if you sign this petition, is under penalty of felony perjury. That, and the other issue on our current lawsuit is the window for the filing deadline, which in Minnesota is tied to the major party primary in the middle of the summer versus the general election in November. Do you have any notes, thoughts on those two out of our 9 points, those two situations we're addressing? And then the other one, the percent, will that be addressed in a future suit?
Right. Well, we filed the lawsuit last year with respect to the Libertarian Party's First Amendment claims regarding the petition requirements. And I've got to tell you that the government regulation of minor political parties relegates them to a political ghetto. I've never seen anything more outrageous. I can't imagine anyone volunteering to undertake the petitioning process for the minor political parties. It's just outrageous compared to the ease that a major political party candidate has in getting on the ballot. So why is it horrific, and why is it violate the Constitution? Well, initially we were focusing on the oath, and we had met a couple times with the political party board here, and we talked through it, and we actually got sold on the idea that the oath was the problem. But then we started seeing the interrelationship between the oath, which basically someone signs it and says they won't vote in the primary election. This is when they're signing the petition for the minor political party candidate. They won't vote in the primary election. And we thought, well, that's horrible. And plus, they also have to indicate that if they do vote, they're subject to perjury and a $14,000 fine and a year in jail or whatever it is. So we were saying, well, that oath's a real problem. But then we saw that the oath was connected to the vote in the primary election, but then it all relates back to the 14-day window in May and maybe early June that you have to sign up the petitioners to get on the ballot. So the state of Minnesota uses the same window for filing affidavits of candidacy for the major political party candidates as the window for the minor political parties to get petitions on their for their candidates to get on the ballot.
And to be clear, a little note for people who don't know, we're not allowed to participate in the primaries as a minor party. So any tie into that is illogical.
Well, that's right. That's right. It is illogical. And so here's what happens from the voter's perspective is the voter is sitting there while the affidavits of candidacy are being filed, and while the candidates who, for the minor political parties, including the Libertarian Party, are collecting their petition signatures to get on the general election ballot. So the voters are sitting there, and they can, you know, the major political party candidates don't need to go to the voters because they just file their affidavits of candidacy. And then the minor political party candidates are out going door to door to get signatures on their petitions. So the minor political party candidate comes to my door and says, will you sign my petition? And then I look at the petition, it says, I swear that I won't vote in the primary election, which is, you know, 3 months later. You know, it's in August, so it's later. And so I look at it and I say, well, I might sign your petition, but it says here that I can't vote in the primary election later in the year. And I don't even know who the candidates are because the affidavits of candidacy aren't due until the end of the 2-week period. Then the Libertarian Party candidate says to me, well, I can't tell you who the candidates are, but you should still sign my petition. So if I insist, I won't sign your petition until I know who the candidates are, the Libertarian Party candidate is going to run out of time because the affidavit of candidacy can be filed at the last moment in the 2-week window, which is precisely the time that the minor political party petitions are due. And so you not only is it illogical, but for the voters, you know, it's unconstitutional. For the candidates seeking voter petition signatures, it's unconstitutional. And for the Libertarian Party, it's unconstitutional. And so for all these reasons, you know, the statute is unconstitutional. But let's take a step back and say, okay, let's look at what they're actually doing to you. So during this 2-week period, you have to go door to door, and the major political party candidate doesn't need to do anything. When the major political party candidate is seeking voters in the primary, he can encourage people to do absentee ballots. He can assure the voter that they can vote in private. He can assure the voter that there will be multiple locations available. You don't have to drive across town to vote. There'll be one in your neighborhood. There are all these opportunities when the major political parties are recruiting voters for the primary election. But when the minor political party wants to get a candidate on the general election ballot, all these hoops have to be gone through by both the candidate, the party, and the petitioner. And it's ridiculous. Now, one of the ways we propose in the complaint, and the motion hearing is going to be in mid-May, but one of the things we propose in the complaint is to simply extend the period for collecting signatures through the primary election date, and that may alleviate a lot of the problems. However, when you consider that, then you're also like, well, okay, if we're going to extend the primary election date to the primary election date, why don't we just have the minor political party candidates on the primary election ballot too? And why don't we just have a minimum threshold to get on the general election ballot? And by the way, that should also apply to the major political party candidates. Let's say you're in a district where it's very blue, and on the primary election ballot you have one Democrat, the incumbent, who's going to win the general election probably, but then you have a candidate for the Republican Party and the Libertarian Party. Why should the Republican Party candidate automatically advance? The Republican Party candidate should have to make a showing of support, just like the Libertarian Party candidate. Now, Libertarian Party wants to be fair to the major political party candidate. We're not going to make you do what we have to do, but we should be able to do what you do and just be on the ballot. And then there could be a threshold, like in a local race, you could use the same thresholds already used, 500 votes. And so the Libertarian Party candidate would have to get 500 people to poll to advance the general election. But so would the Republican Party candidate, and that's fair. And so would the Democratic Party candidate. My hypothetical, of course, that was assumed. But that's the type of fairness we're talking about. But we are so far away from that. I mean, this is basically political activity suppression, intentional, diabolical. It's bipartisan, which makes it worse. And so if you want to know how Minnesota's politics work, look at how the Minnesota's two major political parties treat minor political parties. It's outrageous.
It is outrageous. And now that falls under the Fourth Amendment, I believe, unequal protection, where obviously we have to put our ballot candidate, register him by June 2nd. The major parties at the primary in August, they end up selecting who their ballot candidate will be. So that's a way where we're not treated equally in just that one statute, and we have several listed. You mentioned the court hearing on May 19th. So you filed the complaint, you got a response from the Secretary of State, motion to dismiss. What happens on May 19th? People come, it's open to the public. Do you think the chances are better or worse with the situation going on? What can libertarians do to help push this?
Well, the first instance, the 800-pound gorilla in the room has to be recognized. The coronavirus and Governor Walz's order that everyone has to stay at home. And I know there's some exceptions for essential activities, and gathering petition signatures would be one. But again, why is it that every time that there's something comes up, there's more burden on the minor political parties than there are on the major political parties? So the major political parties will go unaffected. In fact, the Secretary of State is busting his tail to arrange for increased mail-in voting, but there's no sympathy, no embrace, no sort of consolation for the minor political party's cause, which is going to occur in a month or so of having to go door to door. People aren't going to answer the door. People aren't going to want to touch the petitions. They're not going to want to handle things, and the coronavirus is a big issue. And so,
for those who don't know, we had an editorial in the Star Tribune on Friday last week, authored by myself and the chairs of the other two minor parties, that say exactly what you're saying right now. Sorry to interrupt.
Exactly. Yeah, no, that's right. So the instructions that I'm getting, from the party board here is we have to consider in our motion paperwork to the court what the coronavirus means for all of this. Why is 2 weeks reasonable now? When you have the coronavirus. And so the government shows no sympathy, no empathy for the Libertarian Party's candidates at all. But getting to it, then the government is going to move to dismiss the Libertarian Party a complaint, and then we're going to respond with a cross motion for summary judgment. And that means that we're asking the court to adjudicate the claims now. So the hearing in May will be about everything. Now, May 19th is a historic day for the Libertarian Party of Minnesota because that's the first day of the 2-week window. And so we'll also ask for the court to suspend, basically, or enjoin is the technical word, enjoin the rules that apply to Libertarian Party of Minnesota and allow the signatures to be collected through the primary election date. And if we win on that issue, that's basically the lawsuit. And that's a huge, huge win for democracy, for minor political party participation. It's a huge blow to the major political parties. But most importantly, I hope that people recognize that you don't have these sort of diabolical devices used by the government unless there's bipartisan support. So it's both the Republicans and Democrats that need to be diagnosed in light of this symptom. And that is, what kind of political parties would do this? What kind of political parties would violate sort of democratic norms in this way and not allow for competition? And that's where we sit in Minnesota, basically two feckless political parties and a government that overreaches and violates our rights in every way you can imagine.
So on May 19th, 10 a.m., Minneapolis U.S. District Courthouse, room 14W. Should people turn out?
Yes, it's very important for people to, one, be educated about the issue. Two, if they can, attend. Three, if they can't, we'll try to distribute the transcript, or they can watch the coverage on television, radio, and in the newspapers. But it's very important that Libertarian Party members become educated because this is their lawsuit. And so as this case progresses, they need to know what's happening. And if the Libertarian Party of Minnesota can break through, I think that it's going to have a great effect on politics in Minnesota. And maybe, just maybe, we'll have some people in the state legislature who will represent the people's interests.
I really appreciate that. Last two questions. Have you heard anything on people not being allowed to attend future court hearings at this time with the coronavirus, or have you heard of any postponement of cases at this point?
There are, but it doesn't extend into May. So the
Okay.
May hearing is unaffected at this moment. Hopefully, things will clear up by then. If not, who knows how it'll be handled. Maybe we won't have a hearing. That's okay because the briefs will look pretty good. The briefing, by the way, the process starts the first briefs are going to be filed in a couple weeks, and so we're going to be really busy next couple months. We'll be filing 3 briefs. They'll be filing 3. It's a lot of work, but as I tried to explain, the facts are kind of complicated. I mean, it's complicated because you have the oath, the petition, the primary election, the 2-week window. It took a long time. In fact, it took 2 tries for us to kind of really get a good hold of it. And then when we got to the point where, now we understand it. This is the way to present it, that the major political parties are screwing the minor political parties by requiring the signatures to be collected, a 2-week window, 2 months before the primary election. And the voters need to sign the petitions without even knowing who the opposing candidates are. I mean, it's Orwellian.
Right. It's a great term. Erik Kaardal, I want to thank you so much for your time. Thank you so much for working with us and representing us and fighting on our behalf for this. Everyone watching, like Erik said, you need to learn, if you haven't, the details of what's going on. This is all posted on our website at lpmn.org. There's a tab or pull-down menu called Rise, and we have an infinite amount of ballot access information on the bill, which we'll be talking about with Scott Jensen later, as well as the lawsuit that Mr. Kaardal is championing for us. So thank you for your time. I do have one final question as people are holed up. What is your favorite movie?
Oh, I have a lot of favorite movies, but I guess my favorite movie of all time would have to be I keep watching it, so I have to say the Lord of the Rings trilogy. So there you go.
That's a great one to
Real
watch
fashion.
repetitively from your couch over the next couple of weeks, I guess. All right. Well, thank you, Erik. And you have a great day.
You too. Thank you.
All right.